Oh no, there we go. All right, team. So I just mentioned before the reflective pieces. I'm probably going to get that to you guys tomorrow. I've only got a handful still to go. By and large, they were actually much better than I was expecting, and you can take that any way, shape, or form you like. You can either be happy for one or unhappy for the other. They would, on average, they were better than I had thought. So even though you do get a double chance with that, what I'll almost certainly do, and again, this is for the external students as well, if they're catching this, is that it'll probably be on a case-by-case basis. Because after, particularly for you guys, the internal students, after I've marked your exam, I'll probably end up contacting those that need a couple more points. And then we can work together and see if we can find you a couple more points in relation to that. So just be mindful. You can always do a resubmission for that, and I'll explain that a little bit later in the semester. But as it happened, they came out pretty good anyway. So there we go. Just handing around the room somewhere is the task for the next fortnight. Have had a few in for feed forward, which is really good. And I said I'll be working with you guys over the next few weeks to hammer out some feedback, to get that back through to you guys. Because all of these things, you've got multiple goes. And that's one of the really nice things about doing this at the MBA level, is that unlike the undergrad where there's many people, and you've got hoops, and again, most of you guys have come from education systems. You've got to rote learn stuff, jump through the hoops, and it's literally sorted on your grades. You have to memorize the most amount of stuff, regurgitate it as quick as you can in a certain amount of time, and then you're sorted in terms of the raw mark that you get. No double chance, no nothing. That's not really fundamentally how these courses are structured. You guys, you need to be able to demonstrate to, well, usually the person assessing it, both myself and to the external examination people, and for the moderators, that you guys have demonstrated a clear and deep understanding of the subject matter. If you can do that, you can do that in any way, shape, or time, and I'm very happy to guide you and give you as much goes at doing it as you can. Okay? Now, you'll note some of the stuff I'll talk about today will be relevant to that assessment piece that you've got there. It will also require a little bit more research as well, based on things from last week, to do with the electronic communication stuff. That's for the group task. A bit of statutory interpretation. And the Electronic Communications Transactions Act has actually changed. So it's got some new bits in it from a couple of years ago. It's pretty straightforward to read, but you're going to have to go through, look at that scenario, and then come back and then have a little read, have a look at the scenario, and bounce things backwards and forwards a little bit to be able to really get a good handle on what's happening from a legal perspective. Okay, does anyone have any questions at this stage? Hope it hasn't been too traumatic so far. How are your other subjects travelling in terms of stress levels? Oh, really? Oh, wow. Okay. You got many goes. You have multiple goes to do it, and you know your best three are going to count. You got best three. So how we go and how we go about doing those in terms of time and getting them right. I think you'll find over the course of the semester that it'll become. I imagine it'll become slightly less stressful. Maybe. We'll see how we go.
One thing
yeah, right.
Is that since I missed like a class, it seems like the questions are a bit open-ended.
They are,
I wasn't sure like to pinpoint as to like what exactly is the solution. Like, and then I asked my classmates, and they were like, you were basically asking about what codes to go to. Yeah,
that's exactly it. Yeah.
When I did it, I just like went into like whatever is the law, and then like.
Oh, okay.
Whether you know, like I didn't think.
Oh, whether it was a contract issue or a tort issue. Oh, okay, I see. Oh, yeah, sure. Okay.
I did both. I was like.
Oh, yeah. Oh, that's fine. All these things there. Again, those things can come out of the wash. As long as they've been submitted for the feed forward, I'll go through. It'll probably take me a bit of time to go through, have a little read, and I can just give you guys structured feedback. So you can just go away and do it again, resubmitting. So you've got until May to do that. And we'll, throughout the semester, particularly after when the test is on, we've all got a little bit more time. Hopefully we can actually go through. I'll go through with you guys your pieces that you've got in relation to this. Okay, so today we're talking about contractual obligations, also known as terms. And so this really comes back to the that model that I had of the 4 pieces of pie in terms of what when we're trying to think about contract law in the broader sense, First one, last week, we talked about how do you make one. This week, we're going to assume that we've got a contract. And the real question we've got to ask is, though, what does that actually mean? What are our legal obligations in relation to this agreement? And so the key thing to note here, and if you do, again, have questions in your exam and test and so on, you don't need to talk about formation if the question is geared towards analysing terms. We just assume there is a valid contract, all those 7 elements are present. We've moved on to this next phase, assuming that a contract's valid, which 99% of the time isn't the problematic part. What we really care about with contracts and contract law is what is it that we have to do? All right, and what's going to happen to us if we don't do it? And so this week we're going to look at the obligations themselves, not the consequences. That's the discharge, the fourth component of this. But this week we're going to talk about, I've entered into a contract. What does this mean? What do I have to do? And it's really interpreting and analysing these parts of a contract, and in particular, a lot of little rules that go with interpreting these things and types of clauses. I use the term clause to describe a particular obligation. Usually we think of it in terms of a written contract, when you've got multiple obligations, and they're usually separated out into paragraphs. We think of that as sort of the atomic unit, an individual obligation in a contract. We use the term a clause to describe that. And so I'm going to start by talking about the I guess the building blocks of contractual terms, which we call express terms. And I'll be talking about those, the very overt things. And they're different and distinct from what we call implied terms later on, when we're looking at the things that the court comes along at a later stage and does that. So we'll need to go through and classify terms into different categories. I'll talk about the parole evidence rule. That's a rule involving written contracts, specific rules to do with writing and enshrining things in writing. We'll talk about how statements actually end up being terms of a contract. 'Cause it's real easy if there's a written contract. Here you go. It's just. It's a lot harder when it's a combination of oral and written things in a contract. That can be a little bit trickier in terms of trying to work out whether a particular statement forms part of a contract or doesn't. We'll look at onerous clauses, things in a contract that are so horribly one-sided that the courts of common law actually take offense to. You actually can't sell your kidneys or put things so horribly unfair and one-sided into a contractual arrangement, and particularly to scare or tyrannize the other side into performing. You can, however, put in things called exemption clauses. They are things that limit your liability. You can map that out ahead of time. We'll look at signature, what that means. Implied terms, things where the courts come along and said, oh, well, yeah, you didn't write this down, but you actually meant this. They're construed quite narrowly. We'll look at collateral contracts. Those are little baby contracts that people enter to, where usually in a situation where this contract, a little baby contract, is I'll give you something if you enter into another bigger contract. So I'll go through and talk about that. And the final one, probably the most important one, is what we call interpretation. We're actually just going to go through and talk about how you go about reading a written contract. There are particular rules that we use in relation to that. Okay, well, that is today. All right, so starting off with the basics, what is a term? It's just an obligation that has been incorporated into the contract itself. Can I just get someone just to close the door at the back? Whoever's closest. It's always the worst. Yeah, you always end up being the person closest to the door. Oh, close it. And the aircon buttons too. And it really is that simple. Terms are things that we, as two parties, two rational, self-utility maximizing individuals have come together to create an agreement. And in theory, I'm getting stuff, you're going to do things for me, and I'm going to do things from you, and then the net result is we're both going to be better off. And it's really the list of things that we're going to do. And we talk about these as obligations. They don't have to all be written down. Contracts can be a combination of writing and of words, but each individual obligation, we use the English word term to describe those. That's the first piece of jargon, I suppose, that comes up. Now, this first categorization in terms of what I call express terms and implied terms. And the key thing to note is that express terms are obligations that we agreed upon. We had this meeting of minds. We either talked about or some other way gave notice to the other party that this particular obligation is part of the contract itself. And this is different and distinct from implied terms, which can only be done by the court. So express terms are things that we have come together to agree upon. It doesn't, strictly speaking, they have to be all written down. They don't, strictly speaking, have to be talked about at the time. But they're different and distinct from implied terms that can only be upheld or demonstrated to exist by the court. I'll talk about implied terms, I think it's a bit later in the lecture. But we'll start with express terms. The key thing to note with express terms is that the things that we say, the statements that we make that get incorporated into the contract as obligations are express terms. And I'll use this, I use the term a lot to describe particular obligations that we've either talked about overtly, but also can be incorporated into the contract through what we call a course of dealings. So, for example, if go back, poor old Gene. So Gene and me, we've got a contract for a boat. Boat's perhaps a bad example. Possibly a coffee shop or whatever the assignment is there. You can have contracts where you have an overt set of promises that you make. Say you're maybe a florist. A florist might be a good example. You're a florist, you buy flowers, some people come, bring you flowers, and they do this in a very casual way. They arrive, we say, do you want some flowers? And they go, yep. Pay them some money, they give us some flowers. Okay? If we did this over a long period of time, and in particular, the custom or the tradition or the same habitual steps are taken in forming this. They take the flowers and they leave them by the back door. Okay? And they do this over a repeated period of time. You can argue, or certainly make an argument, that in a contract at some stage later, even though we didn't expressly mention that leaving the flowers at the back door was part of the 19th time that I've purchased flowers from this particular flower vendor, it's something that will be expressly incorporated into the contract because it's what has always been done. We've always done that. And at some stage earlier, I did say, as part of this arrangement, please put them at the back. Maybe the first time they came in. Here's the flowers. Can you deliver them by this time? This amount. I'll pay you this amount. Can you deliver them at the back? And that might have happened the first month. It might happen the second month where you actually say that. But then after the fourth or fifth month, you just be like, g'day, how's it going? Okay, the usual, yep. You're not actually expressly stating that. You're not going through and overtly saying, deliver them at the back. But all of the previous times that you did that, we went and they went and were put to the back. And the court say there that, look, that is still going to be an express term. It's something which is incorporated into the contract, even though we didn't actually say it. Another and kind of related form of express terms is notice. A really common one, by the way. Our terms are on the website. When, for example, again, going back to the flower example, if you'd agreed in that first arrangement, oh yeah, all our terms and conditions for purchasing are on the website, sure. Those are still express terms that have been stated in some way, even though, sorry, they exist in the world and they can be determined, but they weren't mentioned, at least not going through line by line, at the point in time where we actually went and formed the contract itself. Been incorporated by notice. Oh hey, all of the remaining terms are on the website. That's an acceptable way of putting express terms into a contract. Okay, that's the that's just a couple of things to note about this. It's pretty high level actually. This lecture. I don't know whether I meant it to be. There's not a lot of technical case law here. They're just, if you can sort of get this bit around your head, what you find is that I'll use this language later when we do more contractual, when I'm talking about contracts with a little bit more depth, and I'll be talking about express terms, and I'll be talking about course of dealings and things like that as well. And it's something to note also in your assessment, that there'll be course of dealings. Some form of course of dealings you'll have to talk about, whether they're express or not. Okay, so these are what's called express terms. Now, kind of one of the kind of annoying features of contract law is that we need terms are classified across a whole bunch of different axes. So we're talking here about this difference between express and implied terms, things that have been overtly stated and incorporated in the contract that both parties can actually go and know about because they've been expressed in the world at some stage, not determined by the court later on as things they didn't talk about, which I'll talk about a little bit later. That's one axis that we're looking about, express versus implied terms. Next week we'll talk about, 2 weeks time, we'll talk about the importance of terms. Some contractual terms are really, really important. Payment is a really important thing. If Jean's buying my boat and she's going to pay me $10,000 and I give her the boat and she doesn't give me the $10,000, that's a pretty important thing. And I'll talk about the importance of terms because it's actually relevant in terms of breach. And we talk about that in 2 weeks' time. That's another axis, though, that we look at terms of a contract and we're classifying them in some way. But there's another, I guess another axis, another form of classification that we have to make in terms of statements themselves. Because a statement that is made in and around the time of formation of a contract, and these can be written or oral statements, can really form one of these 4 things. Okay, it can be puff, which is a technical term, which is an exaggerated statement or claim. A representation, or what we call a mere representation, that is a statement that is made concerning the subject matter of the contract or something related to the contract that is not incorporated in the contract as an obligation. A representation is a statement made in and around the formation of the contract that is not an obligation, it is not a term, which is the 3rd type of statement. A statement which is made that is incorporated into the contract is called a term. Terms have legal consequence. Mere representations do not. I'm going to go and repeat that because actually it's a super important point. There's 4 types of statements that can be made in and around the formation of a contract. The 4th one, collateral contract, I'll come back to that. And puff, by the way, is an exaggerated statement or claim. I'll come back to that as well. But this key one, the number 2 and number 3, are massively important because people can say all sorts of things in and around the formation of a contract if a particular statement is incorporated into the contract, and there's a variety of ways we can do that. It is a term, and it has legal consequences if the other side does not perform in relation to that term. There may only be very minor consequences, but there are always consequences if the other side is in breach of a term. Whereas a mere representation does not have legal consequences. However, some types of representations that are not terms can still have some form of legal effect. And we talk about those next week. They're called misrepresentations. Now, just this key thing to note. Statements made in and around the time of formation can be one of these four things. PUF and collateral contracts I'll come back to. But this key distinction between representations and terms is massive. If something is a term, it forms an obligation, and there are legal consequences if the side does not do the thing that they promised to do. It may only be a very minor legal consequence, but it has some consequence. And that can be really important in law, because often if you go to court, by the way, if you go to court and you win $1, for example, I don't know if you guys have been watching the news much, there's a guy called Fraser Anning. Does anyone know who Fraser Anning is? It's made the news a little bit, where some kid came and cracked an egg on the back of his head. Oh yeah. There's been big news, because it's from a legal perspective, by the way. This is, I mean, it's fascinating. I'm literally going to lose friends over this. I've picked a hill I'm going to die on. The reason for that is that it is still, strictly speaking, an assault. Now, even though you're a public figure, the humiliation aspect is irrelevant. If you or I were standing somewhere and on national TV talking and somebody cracked an egg in our face, that's humiliating to us. We're not public figures. Someone did that to us. You'd be able to sue for the assault, but you'd be able to get what's called aggravated damages. This is in circumstances designed to humiliate. Right? This guy's not going to get that because he's a public figure. You know, he's an incredibly unlikable human being. Right? But that, and this is the key point, actually doesn't justify violence. Doesn't justify the assault. And I said, I've had some heated arguments about this one. Damn you, Facebook. And just the key thing to note, though, if he does go to court to sue the little 17-year-old kid, all right, and he wins $1, yes, you got an egg cracked on your head. You're a public figure, so we're not going to count the humiliation aspect. Yes, your rights were infringed, or here's $1, or here's $100. You win. You win, here's $100. There's a very important thing to note. There's a massive difference between $100, getting awarded $100, and getting awarded nothing. And that difference is that you won, therefore, the other side has to pay your costs. That distinction from a legal practice perspective, and for you guys as business professionals, you guys are going to end up being CFOs, having to make these sorts of tactical decisions with your legal team to sue and to not to sue. That the matter of cost is massive. So just leave that one in the back of your mind. And so coming back to contract law, if something is a term, even if it's minor and it's breached, it has legal consequences. And usually those legal consequences involve dollars, even very small amounts of dollars. But if you do go, you bring an action, you win, the other side has to pay costs. They may not be all your costs, but nonetheless, you do win. And winning and losing is really important. Winning is very important in an adversarial system. Okay, and so I'm not going to talk about this difference between what I say mere representations and misrepresentations. There's a classification for that we'll do next week. But just make note, if it is a representation and not a term, it is not considered to be an obligation under the contract. It can still have this legal consequence if it's a misrepresentation. The innocent party may still get some rights. You may still be able to sue. You may still be able to get some dollars. But it's not a term. And so non-compliance is not automatically going to give you dollars. I'll come back to collateral contracts. So start again. The first of these statements, I've got a full slide about representations. It's even got case law. Great. First of these statements is PUF. All right, so the key thing to note, PUF is an exaggerated statement or claim usually used, business strategy, usually used to differentiate a product in the marketplace. Exaggerated statement or claim usually used to differentiate products that no reasonable person could ever think has any legal effect. In that case, there's that cobalt smoke ball where they talked about this. Remember though, in the smoke ball case, the smoke ball company was wrong. They tried to argue that it was puff, and the court said, well, you're going to have a hard time arguing that something was an exaggerated statement of claim that no reasonable person would have legal effect if you actually went and put £500 into a vault to give people who used your product. Good luck with that. And this, again, for those that end up in terms of giving financial advice to your marketing teams, is a really important point, because it sounds really silly when I say this, but the more silly, outrageous, ridiculous a claim is, the less likely you are to get in legal trouble. I'll say that again. The more outrageous, silly, ridiculous the particular claim about your product or service is, the more outrageous it is, the less likely it is to be considered a term. If it's a term, that's bad. Because if you say something like the Harrier jet example that I had last week, if you collect 10 million bottle tops, you can have a Harrier jet. Well, 10 million bottle tops, when you could actually go and buy them at 15 cents each, that's only, what is it, $1.5 million. Well, it's a pretty good price for a Harrier jet. That seems quite reasonable. Let's go and buy them. And they did. Gave it a go. And I did note that in that particular instance, after this kid had done the application, Pepsi Cola immediately changed the ad and changed it from 10 million bottle tops to 390 million bottle tops, or some outrageous figure. They actually made that change for the same ad and carried on running the ads, which is interesting because, again, how serious the number is matters. In the case of the guys who at Pepsi Cola, admittedly they did win. The Pepsi company did actually win, but in terms of those guys going and the marketing team picking the number to put in terms of number of bottle tops, they aimed too low. They just needed to add 4 more zeros and it would have been fine. The thing would never have come up. And that was poor judgment, really, because it had to go to court. Okay, there have been some cases. These things do come up in the federal courts and other state courts as well. All right, batteries lasting up to 4 times longer. Is that an outrageous or exaggerated statement or claim? You reckon 4 times longer? I think that's a pretty reasonable thing. I'm buying an ever-ready, was it an Energizer battery as opposed to another one? I don't know much about batteries. And you appreciate that it's an objective person. What would a reasonable person without knowledge of the subject matter in terms of general consumer goods, what would they think? Now, it actually doesn't work, by the way, in terms of that completely oblivious person. It actually doesn't work for certain professions. This is really funny. When you're trying to determine whether something's puff as opposed to an actual statement which might have contractual force, if you are doing things involving industries with scallywags, rogues, and those are industries with a reputation for having salespeople who make these sorts of claims, the same rules don't apply. What are some examples of some industries where salespeople make all sorts of outlandish claims about things? There's 2 that I can think of. They're both ones where salespeople make a lot of money. Motor industry, statements about used cars. There is an acceptance, and this is reflected in the courts, that used car salespeople are a bit shonky. I'm not kidding. This actually forms part of the common law of Australia. And so there's an acceptance when you go there that they're going to have a little bit of banter. They're going to have a little bit of showmanship as part of that. And the other one, which is very, very unfortunate, is real estate agents. Reading through the trite that real estate agents publish about houses is just, it's just painful. So here, for example, this particular case is in the South Australian Supreme Court about 10 years ago. Property having immaculate style. is going to be puff. All right, that's kind of a broad sweeping statement. It's not something you can really tangibly turn and say that you could appreciate that a reasonable person would think there was some legal consequence. Whereas saying that something has a perfect presentation, nothing to spend, that is not an outlandish statement or claim. And there the court said, look, it is actually reasonable with a person, knowing full well that real estate agents can be a little bit shonky. This is not so outlandish. When you go to a real estate agent and they say nothing to spend, that is quite reasonable in terms of a person purchasing it to think they don't have to spend money in relation to this property. All right? Or in particular here, in relation to the presentation of that property. When you arrive and find that all of the lawns and gardens are dead, you know, they're going to go back and look at this, and here the courts, and the thing is with real estate is that when the numbers are large, those are the sorts of cases that end up going to court. That's just something to note. When decimal points, and that's why cases involving boats and real estate deals, they go array. So these are really the key things you need to know when you're trying to work out whether a particular statement or claim is crazy. But from you guys as business students, the key thing is that puff statements should be outlandish. And so if you've gone and looked at the marketing team's stuff, for whatever reason, and you look at it and they've made statements that are, you sort of look at and go, oh, actually a person might look at that and think you are actually meaning that a product can make you fly, or something along those lines. Red Bull gives you wings. Like, doesn't actually literally give you wings. But, you know, Red Bull picks you up, or Red Bull makes you run 5% faster. Things like that. And you go, oh, hang on, ooh, that's moved away from being this exaggerated statement of claim to something that turns out could actually be a little bit more tangible. Admittedly, pitching your product as a performance enhancing thing's got other issues, but that's something for you guys to just leave on the back of your minds. Outlandish, good things that a person could look at and say, oh, actually, maybe they did mean that it could do this particular thing. Bad. All right. Going to revisit this, I just mentioned before about terms. Okay. So, for the first thing to note, that was the point I was making just before. If somebody makes a statement in and around the time of formation of a contract, if it is not incorporated in the contract, does not have contractual force. You can't sue under the contract itself for the non-performance or the half-ass performance of a particular statement that's been made if it's not incorporated into the contract itself. All right, but they can still have some legal consequence. All right, so some representations have legal effect, but mere representations is the term I've used. I think Steve uses it in his book as well. I think it's a useful way of describing this. A mere representation is a statement made in and around time of formation that does not have legal effect. All right, because it can't be classified into one of those other 7 categories. All right, and all of those, apart from the last one, I'll talk about contractual collateral contracts a bit later, but the later in this lecture. And the others are representations that are made that actually will have some form of legal effect, but I'll describe what that legal effect is next week. Key thing to note is that if a statement's made and it's incorporated into a contract, that is a promise. That is an obligation. It has contractual force. And the instrument that you're using when you go to the court is the contract. That's the instrument that you use, and that's the cause of action you take. It's breach of contract. You have to use other areas of law, one of those 2 through 8, in order to try and seek some form of remedy. When I say remedy, usually I mean dollars, by the way. Occasionally, there's some corner cases where the remedy, the result that you want to get, is to actually do things like make the other side do what they said they're going to do. All right, there is mechanisms for that. We'll talk about it 2 weeks' time. But the default rule is dollars. When I talk about remedies, it's usually just money. The other remedy, apart from getting to do what they say they're going to do, which is pretty rare, the other one is to undo the contract, actually rescind it. What that means is put the parties back to where they were, which usually, the important thing is, for example, buying the boat is title to the boat. The ownership gets reversed if the contract's undone. Again, I'll come back to that at some stage later in the talks about contract. Okay. So, how do we determine whether or not a statement that's been made in and around the time of formation is incorporated into the contract or not? And there is a legal test that the courts use, and I guess this is the first of the sort of tests I think we've talked about in this subject, because you guys are aware people disagree about stuff all the time. All the time. As I said, I'm probably going to lose some friends over the egging disagreement about this egging issue with Fraser Anning. But where we can't agree, we have to trot along to court. And the courts have to determine who's right. Because, you know, the only reason you go to court's really expensive and very stressful, and there's only one winner, and that is the lawyers. No, joke. It was one adversarial system. You'll have a winner and you'll have a loser. And in most situations, the loser has to pay the winner's costs. But you don't go unless you're pretty sure you're going to win. Now, the thing is, judges, except in very rare and unusual circumstances, don't really make law. They take existing rules and principles, in this case, what we call the contractual intention test, and they apply those particular principles to the circumstances in front of them. Now, usually the two sides rocking up to court, they're both aware of this. They know what the contractual intention test is, and so they're going to be trying to argue that the law is strong in their favour, or that the facts are strong in their favour in relation to what the law already is. There's a famous adage amongst barristers, which is, if your side is weak in the facts, you argue the law. If your side is weak in the law, you argue the facts of the case. What I mean by that is that if the law is clear-cut, you are going to try and argue that the relevant law that relates to these facts these facts aren't actually related to this particular law. They're related to this other law, which would be favourable. All right. Whereas if it's the opposite, if the law itself is good for you, you're going to be trying to argue as much as you possibly can that these particular facts apply to this particular law. You don't want the other side to try and say, oh, no, Your Honour, it's actually this law over here. And so in situations where a statement that's been made in and around time of formation, we use what we call the contractual intention test. This comes from Justice Mason and Cadelpha Construction and the State Rail Authority of New South Wales. I'm going to tell you a little bit about that case because it's kind of funny. Well, it's not funny, really. Went something like this. They were building some underground rail tunnels in Sydney. And the state government had contracted and done a bid and tender for a company called Cadelpha, a big engineering firm, to dig these tunnels. And Cadelpha said, look, we can do this and we can meet the timeframes that you want as part of this contract if and only if you let us run 24-hour shifts, right? Which is a bit of a problem because the noise rules and things, that strictly speaking, the state government would actually have to go and pass some laws to allow this, because the existing law said, look, you can't have that noise in these places at that time of night, in the middle of the night, right? And so, so they did this, enter into this contract, and the difficulty that then happened, like anything when you're dealing with governments, guess what happened? It was an election, and what did the new government not bother doing? They didn't bother going and getting that exemption. And so Codelpha ended up, of course, being in breach. And so the State Rail Authority, it seems really unfair, doesn't it? The State Rail then actually went to sue them for being late in terms of their contract. And they're like, but you wouldn't. You were the ones that stopped us from doing this. Well, it wasn't us. It was someone else. But a whole bunch of principles actually came from this. And you find that this is the case with issues often to do with contract law or other areas of law where things really need to be mapped out and explained. What the court will do is, if the facts really justify it, they will go through and explain what the law is. Oh, hey, look, there seems to be some ambiguity here. Let's map it out. And usually what they'll do is they'll actually do in a great deal of depth, map out what the existing law is, and to just restate what the existing law is. They're not going to change anything. They're just saying, look, this is good law, this is good law, this is good law, but in relation to this set of circumstances, this rule, and again here in terms of this contractual intention test, really needs restating or explaining in a new light. Sometimes using contemporary language. Sometimes you'll find judges will reread old cases from 200 years ago and re-explain them, just to remove some of the jargon from old language. Because to be honest, for non-lawyers, trying to extract legal rules and principles from 200-year-old decisions is very hard. And you've got without using quite fancy databases to go through and find where these things are, you've got no real access to it. And they're all private, by the way, too. You can't just go through the public things. Google's pretty good with things like that these days too, but it's something to just make note that doing these things in the common law, occasionally the High Court will actually just go and map these things out, which they did in, 1982. And so you'll find that particular case, Codelpha, they went through and just mapped this out to explain it. So that case citation I'll use for a few other cases as well. But in a more recent case, in that Toll and Alpha Farm, they went through and explained that in even more detail. Particularly is that the lead judgment, the judgment that the subsequent jurists and courts looked at was actually only from one judge in Codelpha, which is Justice Mason. Okay, the key thing to note about contractual intention test is that whenever you see this, what we call an objective test, and this is in law generally, if you ever hear this term, an objective test, what that means in lay speak is what would a reasonable person do or think or act in a certain situation. We as lawyers use this term objective test. It's a reasonable person test. And here they've said, the High Court said in the Alpha Farm case, statement is a term if a reasonable observer would think that both parties intended for its truth or the substance of the promise to be guaranteed. Both parties would look at this particular statement objectively. And so it's not whether I thought that this statement, and an example here might be, again, I'm buying Jean's boat, $10,000. And we're making a statement. I'm making a statement, asking questions, and just in passing, in relation to this boat, and we'll say we've got a standard form boat transfer thing. I actually haven't bought a boat, and I'll pop in a little kayak in Australia. I presume there's a little registration thing, filling in a form, and I just happen to ask questions. You know, is it a good boat? Oh yeah, it goes really well. I've got it to go 20 knots and go. I've been fishing all around Magnetic Island, and okay, that's cool. And yeah, it can get around Magnetic Island in half an hour. All right, and so those statements that are made, all right, can get around Magnetic Island in half an hour. The courts again, when doing this, they're not concerned about whether I think that that's part of the contract or whether Gene thinks that statement as to whether it can go around and a guy and a half an hour. It's nothing to do with us. And this is a key feature of law in the broad sense. When you see this reasonable person test, it is not about us, it's about what the jury would think. When they come in, the fact that I think it or the fact that Gene doesn't think it is absolutely irrelevant when trying to determine the results of these types of reasonable person tests. So they're a reasonable, competent observer, a third party, looking at all of the facts, looking at how we talked, looking at how we arranged to exchange money or registration, looking at the banter that we had, whether we're just laughing about it and having a few beers. Oh yeah, was it silly? Was it an exaggerated statement or claim designed to differentiate the product? And it's all about what the jury would think. If you got 12 of your peers to listen into all of those things and be armed with all of the facts that we would provide the court, what would they think? Okay. Would they think that that statement was intended for its truth to be guaranteed, enshrined, guaranteed in law, to have some consequence if it wasn't true? Okay, so that is a test that's up to the jury. But there are 5 things that the court, and this is a good example actually, of if this was a jury test, the judge would have to explain these 5 things to the jury because these 5 factors must be taken into account when determining whether or not this particular statement was a term or merely a representation. All right, and the first of these is this special knowledge or skill that the parties possess. And that goes like this. And this comes from Oscar Chesson Williams. That is the purchase of a car. This, I think both of them, the first... No, it's not. The second one's a quote. This is a car case where a person came to buy a car. Sorry, no, that's not true. Sorry. A person came into a car yard to sell a car. All right? And the person selling the car had said, oh, this is a 1940 model Ford, whatever it was, or a 45 model. I think it was a 1940 model. All right? And the person selling it had the book, you know, the little manual, little book that comes with your car, instruction guide, how to drive, whatever it is, you know, how to change the oil, all that sort of stuff. It comes in a car. And so that was fine. And the car dealer accepted that. And then later on they found out that the book was wrong. Well, it turns out it was a 1935 model. And it was worth nowhere near the same amount of money that they'd paid this person. And so they wanted to seek some sort of compensation. And the court said, well, there, no. You are the expert. The person selling the car has no special knowledge or skill. You are the ones with the expertise. Therefore, when they are making the statement, it's far less likely that a reasonably competent observer would look at that and say that was intended to have contractual force. The fact that they said it was a 1940 model, that's you had the skill. If it was the other way around, yeah, if the person was buying it off the car yard and the car yard pulled the book out and said, this is a 1940 model, and the person had bought it, absolutely. So the reverse would be true. You'd be much more likely to consider, or the court would be to consider that is a term, because they are the ones armed with the knowledge and skill. The first consideration you have to take into account. The second one is to do with the type of language that's been used. When I've used the term here, promissory, which means, does it sound like a promise? Does it sound like it was designed to have this force, to this contractual force? Was it designed or spoken in such a way that the listener would listen to it and think inherently that it was a promise of some sort? And the J.J. Savage and Blackney was to do with a boat. And as part of talking about it, they'd mentioned, the boat can do In fact, it's both similar to Magnetic Island, actually. Yeah, the boat can do this many. It's the top speed. The top speed I've seen was 21 knots, and the person bought the boat was nowhere near 21 knots. And the question is, well, was that promissory in nature? If I say that the fastest I've ever got up to this speed, is that a promise? Probably not really. If you say, yeah, it can definitely do 21 knots, that's much more promissory in nature in terms of what we actually said. That makes sense in terms of that. That's the nature of language. Okay, our time of formation. If you are making the statement, as Jean and I are having this chat while we're exchanging paperwork for the boat, it's way more likely the courts are going to think that it's going to be a term than if it was a statement that she'd made 12 months ago when we were having beers and she was talking about the boat. So if we'd talked about this boat that she'd had, but it wasn't until I didn't go to buy it, until 12 months later, the courts are going to say, nah, that's a statement that wasn't made in and around the time of formation. Therefore, it's much, much less likely that we're going to consider this to be a term. Okay, the next one is writing. If we can be bothered writing this down about whatever it is, being able to go around to Magnetic Island in this amount of time, it's way more likely that we intended for that to be, or an objective, reasonably competent third-party observer would look at it and say, that was definitely intended to be contractually incorporated as part of the contract, to actually have contractual consequences. All right, if we can be bothered putting it into writing, there's much more weight. Because contracts can be a mix of oral and written terms. It can be a mix of the two. They can be just oral, they can be just written, or they can be a combination of the two. And often this test is used in situations where it's a mixture of both. So you've got some things in writing, but we do agree that it's a combination of the two. Okay, and the last case is that is it important? And this can be important to either party. Van Aerschot and Chappell involved a guy asking a real estate agent, not even kidding, does it have termites? No, I don't think so. Kind of an important thing to know, you might think. And so even though the court accepted, oh look, yeah, clearly the language wasn't promissory, but it was super important to the person buying a house whether the thing was filled with termites or it wasn't. It's way more likely an objective, a reasonable person, reasonable third-party observer listening to this would think that that was intended to be an actual term to the contract and have contractual force. Okay, that's clear as mud. So just appreciate that those 5 things the court will analyze, and I'm pretty sure in terms of your assessment, this is going to come up at some stage in terms of doing this sort of analysis in relation to a contractual matter. So just leave that one on the back of your mind. So this test that is used, and the tricky thing, and this is where things start to get tricky in terms of law as opposed to economics, accounting, management, other disciplines, is how to express this thing. If you're given a problem scenario, say in your exam, and a person's making statements, it'll be up to you guys to explain these rules and principles and then apply them to that particular problem as part of that exam to actually come out. And just make note, there aren't right or wrong answers here. It's all about how you argue. This is the annoying, very, very annoying thing about law. I came from originally, I think I enrolled science, actually, my first degree in uni. And I was always angry when you have this waffly legal mumbo jumbo that could go either way. Wanted to have right and wrong. I like doing mathematics, doing accounting, those things. Does it balance? Yes. Tick. Full marks. Law, it's about the strength of argument. And sometimes the facts that are provided for you when your client walks in and says, oh yeah, actually I stabbed the guy, it's really hard to defend people like that. You're trying to make an argument, but it's hard. And this is a situation where there's a framework that the courts will use to try and determine whether a statement is going to have contractual force or not. And these are the factors that are taken into account, and these are the sorts of things that people argue. And so I'll leave it to that for the first part. We'll take 10 minutes. That's all right. I'll come back in a little bit. All right. Now, I kind of lied. You guys remember doing physics at school? Remember doing physics at high school where you'd learn things like you'd learn Newton's laws. You'd do physics and you do this, that, and the other thing, and then the next year they would tell you, oh, yeah, all those rules that Newton said, I mean, they're kind of true, even though they said they were universal and true everywhere in the universe. But turns out there's this extra thing you need to know as well. And then you'd learn quantum mechanics or something similar. Then you learn about relativity, and then the year after that they'll tell you, oh, that stuff we did in relativity, oh, turns out we kind of lied to you about that, and it doesn't really work in relation to the model of the atom. And it seemed that every year they'd pull the wool, pull the rug out from under you every single year. I find it was just a series of lies doing physics, but I didn't do it beyond stage 2. Anyway, so just before what I was talking about, contracts that are partly oral and partly written. Now, there's a really important rule, super, super important from a professional and a commercial practice, and that is the parole evidence rule. And I have to tell you this story because I'm a legal practitioner, but I very, very rarely end up going into court for things. So it's only been like, so I've gone to the tribunal like 2 or 3 times. And I went to one last year. I set it as the assignment, the actual stationery order that it had, and the actual things that were said, had to go to the tribunal, and I lost. The reason I lost was because of the parole evidence rule. Now, I'll explain what happened. I bought some stationery from a company and involved for my kid's stationery order at Kerwin School. He goes to the Kerwin. He was only 7 at the time. He's 8 now. And I bought the stationery, and I had read the newsletter that the school had released in December. This was January by the stage. I knew it was only a couple of weeks before the school started. I probably should do the order. I remember reading the newsletter that said, oh, you had to have them in by this certain date or they'll get a lower priority. I'm like, don't really care. Went to the website, did the ordering, and was aware that the contractual terms were intended to be enshrined in writing at that point in time. What that means is that other extrinsic evidence, when your contract is intended to be wholly enshrined in writing, is actually precluded. It's stopped. You cannot rely on that material as being terms. This parole evidence rule, or PER, says if the 2 parties intend to enshrine a contract in writing, all other material, both oral and written, is excluded. It cannot be a term. And so, armed with my knowledge of the parole evidence rule, I went to QCAT. There's one very, very big problem that you may or may not, and again, I'm going to get to go over your group assignment from last week and talk about QCAT. There's one very big problem with this, and that is that QCAT is not bound by the rules of evidence. And strictly speaking, the parole evidence rule is actually not a contract law rule. It's a rule of evidence. What that means is that the tribunal can disregard it, which they did. So I lost. And I thought about paying the $400 to appeal, but I was only going to win $90. So I gave it away. And I'm a little bit sad about that because I think it would have been interesting because you actually at this point we're going from the tribunal to a court and arguing the matters of law where the rules of evidence do apply would mean that that earlier material was excluded. All right. But anyway, that's my story. I'll probably revisit the story because there's a couple of other things that come up in contract law from the thing from last year. So, yeah. All right. So the key thing to note here, look, it's really important from commercial practice. If there is a written contract, by default, all statements that are made in and around the time of formation will not be terms. If the parties intended the contract to be wholly enshrined in a particular document. All right, it's actually a really important rule, because when I say it's a rule of evidence, it's really to do with practicality. When things go wrong, when they go pear-shaped, when you're trotting off to court to argue stuff, it is a pain in the proverbial backside if you have to try and get people to come in and give oral testimony about what they said and they didn't say. So going back to Jean and me buying this boat, oh, I'm buying Jean's boat? Yeah, I'm buying Jean's boat. In that situation, us having to trot along to court to actually say, Simon said this, Jean said that, bring our witnesses, cross-examine those witnesses, is a royal pain. It's just time-consuming. It is inaccurate. We might have different recollections about what we said. Rules of hearsay apply. I can't say what Jean said. We have to call her in. She has to say what she said. It's frustrating. It is much easier if there is one written instrument to just read that. That is how courts do it, and that is why writing is so important. Enshrining things in writing, by default, will exclude. If you intended to do that, both parties intend a contract to be enshrined in writing. So it's an important thing to note. When you are negotiating, this is really the key thing. Stuff that comes up in negotiations, and that's from the Kidalfa case as well, is not part of the contract if it is then enshrined in writing. The fact you negotiated about it at this point, you see, one person said this, they said that, if it's not put in the written document, it's not a term. May still have legal consequence. Remember I mentioned Estoppel and other representations, but it is not going to be a term. It's immediately giving rise to a claim for dollars for a breach. Okay, but there are some exceptions, and we do need to note these. The first one is that we can agree, or we can intend, to actually have a contract which is a bit of this and a bit of that. And we can have in our written instrument, it said, oh yeah, we intended to enshrine it in writing. Oh, but in the written instrument it says, we also incorporate statements made orally at this particular point in time. Oh, we've mapped that in. Okay. And so that if we didn't intend for absolutely everything to go in this document, parole evidence rule is not going to apply. It has to be clear though. You've got to make it unambiguous, because the courts by default, if there is a written instrument, all right, sorry. The fact that there is a written instrument is usually a clear indication that the parties intended for it to be enshrined in writing. Push. Someone grab the button at the back. Because there's two aircon units. Okay, Estoppel. I should talk about Estoppel next week. Week after next. Estoppel is in situations where there is not, strictly speaking, a contract, but it creates some form of injustice. In other words, where one party thinks that there is a contract, the other side knows that there is no contract, and yet lets the other side carry on, do what they're doing. They think that they've, and again, this is from a case called Walton Stores, they think that there is a contract to develop, and we're going to pay them. Turns out the regulations say that we can't enter into this contract. We'll just let them carry on building the building on our premises for 6 weeks. No, you can't do that. And that will allow situations where there is an instrument, a written instrument, for the court to actually make an exception. Hey, look, you made statements in and around the time of formation. For whatever reason, there is a defect in this contract, and we are going to hold you to those representations that you made. That's how Estoppel works. A situation where an injustice is going to form, where one party is relying on their strict rights, usually to not, usually in situations where there is no actual contract because of some defect somewhere else. All right, but the other side thinks there is. If you let one side come, do what they think is their contractual obligations, and it turns out that there actually weren't any because there was some form of defect, that's, you can rely on Estoppel and equity. And I said I'd come back to that in 2 weeks' time. All right, collateral contracts. I might just see if I've actually got collateral contracts further down. I'm not sure if I do. I think I do. Oops. No, maybe I don't. All right, I'm going to have to talk about collateral contracts. Oh no, I do talk about them later. Nope, I'll come back to that. And implied terms, which we'll definitely come back later on. So these are exceptions. A collateral contract is where there are statements that are made. There is a contract, and there are some extra statements made, and these statements actually induced one party into entering into the main contract. So if those representations are made, here's the example here. I'll buy Jean's boat. I'll enter into this contract to buy your boat for $1 million. All right, and we're going to enshrine that all in writing. So the parole evidence rule is going to apply because we're intending to enshrine it in writing. But as part of entering into this contract, Jean says, "Oh, can you know, it'd be really good if you, I don't know, you know the principal at Townsville Grammar. Can you just organise for them to get my niece into grammar?" And I go, "Oh yeah, sure, yeah, no worries, I'll do that." All right, that's a representation that's been made in and around the time of formation, but the parole evidence rule excludes that from being a term of this main contract. What they can do though is say, well, what instead it does is forms a second contract itself. Remember that a contract requires consideration. I'm providing this consideration of trying to get Jean's niece or nephew into Townsville Grammar. That's what I'm offering for this little baby contract. What is she offering? To enter into the main contract. That's her consideration as part of this little baby subsidiary contract that we call a collateral contract. I'll come back to that in a few minutes. Okay. Notice. Now, we talk about notice. And this is actually part of your assessment, the assignment for the PBL task for this fortnight. All right, so a couple of things to note. You can have terms incorporated into a contract, express terms, even though those terms weren't presented to the other party, strictly speaking, at the face-to-face when they're entered into this arrangement. And even though these cases are all quite old, websites are a good example these days. Oh, hey, all the terms are on our website. So a few things to note. This is valid. You can do this. You can say, yes, we're entering into contract now, but all the terms for doing this are on our website. You know, click here if you want to go and read them. You know, we're quite common. Let's face it. How many times have we scrolled to the bottom and just ticked accept? Have you read those things? Although, funnily enough, I'm actually having dramas. Oh, I read the terms of a contract, or rather an arrangement to doing tutoring for one of the schools. It's the Indigenous Studies schools, and they've outsourced it to a third party. I went and read their privacy policy and said, nah, you're not having my data. And yeah, it might turn into a bit of a drama. Watch this space. I'll tell you how it gets on next week. Okay, so this can be done. You can do this. And there's a couple of kind of famous cases here and where they talk about this. So that second point, Ollie and Marlborough Court Hotel involved an exclusion clause. Exclusion clause, by the way, is a clause which is designed to limit liability, both in tort, which is an area of law we talk about civil wrongs, where you wrong someone else, but you don't have a contractual relationship. So in tort, and also in contract itself. So you can limit your liability on a contract. But put in a clause that says, in the case of this hotel, the hotel will not be liable for any of your lost stuff. Seems a reasonable sort of a thing, even though, strictly speaking, the old innkeeper's rules of ye old England actually would render them liable up to a certain point. But you can put that in the contract. We want to have this as a term. The trouble is, this Ollie and Marlborough Court Hotel is that the person went at the front desk, at the concierge, entered into the contract, all right, signed the little form, and it said, the remainder of the terms are in the room. What's the problem with that? Well, you've literally, you can't read them until you've already gone up to the room, and they're on the back of the door, funnily enough. And so it's not at time of formation. And so that's why the information for where the terms were actually has to be done before you enter into the contract. Otherwise, it's logically impossible for a person, a rational, reasonable person, to actually know what it is they're getting into. And this idea of reasonable steps is interesting because they, and this comes from Thornton and Shoe Lane Parking. This case comes up a few times. This is a guy called Lord Denning, one of the most famous jurists, judges, British judge in the 20th century. He died in 99. And he, in this case, this was the 1971, this was to do with parking. Seriously, this is a car park court case. Went all the way to the Queen's Bench. It was to do with these new fangly machines where you could get a ticket and you didn't have to talk to a person. That was a high-tech thing at the time. And a bunch of legal principles actually came from this case. But the one we're concerned about here is the fact that when you go into the car park and you get your ticket, all right, where the sign is positioned is very important. Because when's the contract formed? When you pull the ticket out, the boon comes up. If you then do that and then you drive in and then you see the terms of conditions, is that before the time of formation or after? It's after. And so and again, Lord Denning said there, you've got to make reasonable steps to draw the attention of the other party about the terms and conditions. And for something like that, actually having to get out and physically walk around the other side and look at it, well, that's going to be too hard. And that's why you'll find when you go to car parking lots, because these cases have been around a long time, when you go to get your ticket, that'll be where the sign is. It'll be just before you actually enter into it. It won't be just beyond. And don't try this, by the way, at the Townsville City Council. It's very expensive. Just trust me on this. It's real expensive. Don't take the council to court. Okay.
If you call the council or somebody and says that your call is not being recorded.
No, the thing is the council, because they have a statutory regime under the Transport and Other Road Users Management Act. They're allowed to charge fines and to have this, that, and the other thing. It's difficult to challenge. Not that you can't win. You can win, and the council, the head of the council legal team said, "Yeah, you can win if you go to the district court." They hate the council. Just appeal it, and then we'll appeal to the Court of Appeal, and then make you pay our costs. So that's how that works. It's a little bit. I got strong armed, and so just make note that this notice, it has to be reasonable. You have to actually demonstrate that. Another case here, I haven't got it on here. Interesting, is Victoria Laundries in Newman. There was a laundry company that came to do dyeing, I think, and they went and bought. And it's basically these ticket cases. The actual terms and conditions were on the back of the receipt. All right, the terms and conditions are printed here. So you went, got the docket, signed to pick the laundry up. Yeah, just sign this to demonstrate. Just sign this for to say that we've taken your stuff. Oh, okay. You sign it. You don't actually notice until afterwards, until you turn it over, that the terms and conditions were on the other side. Because that's what they tried to argue. And there they said, look, the notice has to be reasonable. You actually have to say, the cashier has to say, oh, by the way, the terms and conditions are on the other side. So when you're signing it, oh, look, they are too. Okay, cool. We will not pay for anything that gets damaged and so on. And so it's going to be reasonable steps. And you can never define what a reasonable is. And this is the trouble about these objective tests. You'll never hear any person say or try and define what reasonable is, because it's always a test for the jury. Okay. That's incorporation by notice. You can, however, as I mentioned earlier, have prior dealings. If you've come, and I think it might be in your scenario, actually. All right. Balmain and New Ferry and Robinson is the sort of case that gives lawyers a bad name, because this guy used to catch a ferry from Balmain, I presume, to somewhere else in Sydney. I don't even know what Balmain is. I don't know Sydney very well at all. Is it in South Sydney? I don't. Do you guys know Sydney very well? Anyone? Is it somewhere in the south? That's where the Tigers were from. I don't know, from years ago. Is it by the water? Otherwise, I'm going to sound really, really, really silly if I have no idea. I presume that this is the Balmain that there is being referred to. So I presume it's by the water. I genuinely don't know. So anyway, he used to catch this ferry. And the way the ferry worked was that to get onto the terminal, you had to put a penny in. And to get out of the terminal, you had to put a penny in. All right? And so this guy, clearly a lawyer, paid the penny to get in and refused to pay the penny to get out. All right? And he argued that this, I'm not even kidding, amongst other things, he argued this was false imprisonment because he had entered into a contract when he went in, and therefore, why should he have to perform more when he went out? That wasn't part of the contract. That was part of his argument, and he argued that he couldn't leave the terminal without paying the money to get out, so therefore that was false imprisonment. He lost all of these things, by the way. And but this actually went to the Privy Council, even though it's got a CLR, which is a High Court case. It actually went to the Privy Council. It went all the way to England to hear this case. This dopey lawyer in the turn of the previous century, I should say. And what the court said is that, look, yeah, you might be right if this penny, putting the penny in, was part of the contract, except that you'd done this for 2.5 years. And so therefore, the performance of penny in when you walk in and penny in when you walk out is going to be incorporated into this contract overtly, expressly, through what they call prior dealing. You've done this over a long time. And therefore, the terms of all of the previous contracts that are essentially the same are going to be incorporated into this current contract. And if you did want to object, you really need to do it the first time. That's not to say that you've consented. It's not a consent thing. It's just, and they do say this later on, if the thing is regular and uniform, you're getting or buying some product every single month and do the same thing, buying the rose, some flowers every month, getting them delivered to the back of the store, month upon month upon month. That's the key aspect to this. It has to be regular. And it had to have been actually part of a contract at the start. So again, going back to the Balmain ferries, the first time he went in, he paid the penny, accepted that as part of the contract, and accepted also when doing this that the second part of performance is to pay the penny to get out again. All right, so his performance in terms of tendering payment has to happen twice. That's fine. And that happened the first time. It went without a hitch, really. And that's really this key thing. But that last one in terms of the document must be contractual. You can't use non-contractual documents, packing slips, and try to argue that they are actually contractual instruments. So even though, while I've said before, and I think your problem scenario might have something relating to things like this, even though we may have had this dealings where we've had a contract, bought and sold stuff multiple times, that doesn't mean that signing the delivery docket is actually assenting to a contract. It's not, strictly speaking, part of the contract itself if it wasn't actually a contractual written instrument. And this Rinaldi case involved something being liquidated, I think, where they tried to argue that this, where you've been buying and selling things on a regular basis multiple times, in this last particular time, which guess what, was just before something's about to be liquidated, that signing the packing slip was enough to take possession of the goods. So they said, no, it's not a contractual instrument. Yes, we can incorporate contractual stuff through course of prior dealings, but in this particular case, each of them, the actual contractual instrument, said that the title only transfers, I think, when it's paid for. What is called a remalpa clause. Title doesn't pass till the goods are actually paid for. So we as the seller can go and grab them if you don't pay. All right. These are lots of little rules, by the way. Little rules in terms of contractual terms. And this one's great. This is, and Lord Denning described this case, Lestrange and Grakov, as the lowest point in 20th century contract law jurisprudence. And it goes like this. If you sign a contract, you are deemed to have read it and accepted all terms contained inside it. I will say that again happily 3 times. If you sign it, you're deemed to have read it and accepted it. That is still good law, and it is one of the harshest rules you could possibly imagine, and it is good law. It's a good law. It's not very nice law, but it is still the law of contract in the state of Queensland and the Commonwealth of Australia. If you sign a document, the law deems you to have read it and accepted all of the contractual terms contained within. Whoever actually does that, next to no one. Next time you commit your signature to a document, I bet you're going to pause. Just after hearing this, you are deemed, so, you know, oh wow, the term in here says I have to give my second child to whatever. Look, there's been a lot of criticism about that, but fundamentally that is the law. That is the basis of our contract system. And again, it comes down to convenience. It's convenient when there is a contract that is written and enshrined entirely in writing, signed by both parties, to be able to use that instrument as the entire contractual dispute, or the one-stop shop for looking at all of the obligations that's contained within a contract, and not having to go back and find out whether one side assented to some or all of them. Not having to do that is very, very convenient. So the rule in Lestrange's case is really a rule of convenience in contract law. But it is good law. And when you've signed it, so from this point forward, when you're presented with a document that looks like it might be a contract, yeah, you might want to read them. Or say no. It's the other nice thing. As we get older, I found it much better at saying no to things, like tutoring for the school, the Indigenous school. Okay, so just make note, there are some exceptions to that, though, and that is where there's some sort of fraud. Somebody says to you, and again, this is Curtis and Chemical Cleaning was the case I was thinking of, not Victoria Newman. If they say to you, sign here for your, to demonstrate that we've got your goods, or sign here to say that we've accepted your goods, but it had contractual terms on the other side, no, that's not going to count. If they tell you that a particular document is something different to an actual contract, you're going to be fine. You have to prove, of course, to the court that that's what they said. Oh, they said this was just a packing slip. I asked them whether it was a contract, and they said, no. So I signed it. That's fine. There's another rule too. If you're functionally blind or illiterate, then you can get out of those things as well. And again, you find this too, where literacy rates are climbing in development. Obviously, a place like Australia, they're very high, but you'll find in India that rule in terms of literacy is a little bit more pertinent in rural areas. That's changing, but there are still mechanisms out of that. And I presume that that's been codified in your commercial code. I don't know. Should find out, actually. I'm going to be on my to-do list. But yes, but you appreciate this. These are old rules. Literacy, if you go back in Australia 150 years ago, before Australia, Queensland 150 years ago, more people were illiterate. And therefore, that was more of a rule. Now, good luck. Good luck trying that. Leave it in the back of your mind. You signed it. You've deemed to accept it. Both read it, you've deemed to read it, and accepted all terms within. All right. Next thing to look at, again, particular types of clauses. These are called exclusion clauses. An exclusion clause is, again, where one side's trying to limit liability. Now, in week 7 or 8, we're going 8, 9, 8, we'll be talking about tort. In particular, we're talking about the tort of negligence. Negligence can happen in the absence of contracts. If you have a duty of care to not hurt somebody, and you fall below the appropriate standard that's required that duty of care entails, and you actually do end up hurting somebody, then you will have to compensate them to put them back in the position they were in. But you can limit this. And this is a pretty common mechanism for when two parties come together to try and map out what's going to happen when things go wrong. And the courts are really happy for people to sort their own things out first. And so they, prima facie, will let you put in clauses into contracts that can limit one or both parties' liability under that contract itself. Now, if we step back and think about this for a second, if you've got two parties in a contract, all right, two abstract parties, which party is more likely to be able to force the other one to be able to adhere to exclusion clauses? It's going to be the more powerful party. All right? Has anybody here flown Jetstar? I love Jetstar. They're just so easy. It's the lowest hanging fruit, I swear, in contract law. Has anyone flown Jetstar? Come on, be honest. No one's flown Jetstar? Oh, okay. Oh, yeah, no. It's out of principle. I got literally a friend who literally won't fly jet trash. Oh, no, I'm not doing that. Okay. Jetstar are a low-cost budget airline. They run on the seat of their pants, and you pay the lowest price, but you've got no negotiating power at all. When you go to the Jetstar website, can you negotiate on price? Nah. Can you negotiate on times? Nah. Can you even locate their head office to have a complaint? Nah. You can't do anything. They're the hardest institutions that I've found to deal with in this country, and that's by design. We've got no power in relation to this. And from Jetstar's perspective, these are our terms. If you don't like them, fly Virgin. That's it. That's essentially how they negotiate. Now, Jetstar, along with many other, obviously large entities that have what we call standard form contracts, when you go into the website, here are our terms, they will have clauses in there that are designed to limit their liability for when things go wrong. Do we get to negotiate? Not at all. So as a result, the courts have recognized for a long time exclusion clauses are often unfair. And as such, the courts, a little bit of judicial activism here or there, it doesn't hurt, have basically bent over backwards to try and force companies or force entities trying to use exclusion clauses to do it properly. And a couple of things that they say, and the first two here are, the first thing, if an exclusion clause is too narrow, for example, again, flying Jetstar, we will not be liable if your bag gets destroyed while in the cargo bay. All right? It's fine. Okay, sure. Not liable. Or we'll be liable only $100 if your bag's destroyed in the cargo bay. What happens if while you're flying, the cargo bay flies open and the bag falls to the ground? Where was it actually destroyed? 10,000 feet down there. And so, again, courts are very happy where parties have tried to put in exclusion clauses where they're not wide enough to actually cover a particular breach to say, nah, doesn't apply. That's a little bit of a trite case, though, because big entities are going to try and make these things as broad as they possibly can. And so, though, the flip side is also true. If you make an exclusion clause so broad, so broad, that won't count either. And then coming back to Jean and me selling this boat, and so Jean, she's a wily lass. She's put in this contract. I won't be held responsible for any damages whatsoever, for any tortious action, as well as for any breach of contract that I may have. All right? So she's put in the clause, I won't be responsible for any breach of contract whatsoever. All right? So pay her the $10,000. All right? And I say, okay, where's the boat? She says, what boat? What boat? It says here, I can't be liable for anything. What boat? Don't know what you're talking about. Wanders away. Protected by that exclusion clause that says I can't holder responsible. Now that renders the entire contract meaningless. All right. So the courts have also said that, look, in situations where you make a contractual clause so broad that it makes performance of the terms meaningless, that's not going to count either. All right. So exclusion clauses can't be too narrow, but they can't be so wide as to render essentially a one-way contract, which, remember, in terms of consideration, isn't actually a contract. One side doesn't have to do anything at all, not a contract. Does that make sense? Like that? It's not too narrow, not too wide. There can be, though, sometimes where the courts are looking at clauses, and those clauses in the contract are so unbelievably burdensome on one party. All right? So burdensome. The courts have found another mechanism to really try and make parties not do this. It's okay to have contracts where you're getting a lot out of it and they're not getting much out of it. That's fine. Courts of common law, ye old England, don't care. We don't care how fair things are. What they do say, though, if you've got a term in a contract that is absolutely horrible, you have to make extra steps to bring them to the attention of the other party when they enter into it. Okay? And so this example here of this interphoto picture library in Stiletto involved some marketing prints. Now, going back to the early 80s, this case was, when you're doing some marketing, and we sort of think this now, you can go to a marketing company and find some stock images or stock prints where you go through and you look at it. And they said, okay, there's this picture library said, yeah, we loan these things out. Okay, it's fine. So you borrowed a whole bunch of them, sure. What they didn't say, though, is that you can borrow them for 3 weeks for, like £10 or something like that. And then every day beyond that is £5 per slide per day. And if you borrowed a couple of hundred slides and you return them 6 weeks later, and it turned, this thing was £700 turned into £9,000. So like 10 times as much as the original contract or more. And so this did go to court because once I guess quite reasonably wanted to enforce the contractual rights. We want £9,000. You're only supposed to pay us $700, but you breached this. Therefore, strictly speaking, it's enshrined in the contract. You signed it. So you clearly read it and accepted all the terms contained within. We'd like our £9,000, please. And the court said no. Not because we're not saying that's not a term. It is a term. But there is a rule in contract law that says if something is so onerous and burdensome on the other side, and the key thing to note here, in relation to the contract itself. All right, so again, going back to Gene and me selling this boat, $10,000. If there was a clause that said, I put a clause in the written contract that said, if this boat's defective, I want you to pay me $100,000. Right, that is an onerous clause relative to the contract amount. All right, and so as a result, it's okay to have these sorts of clauses, but you are obliged to bring them to the attention of the other party. Usually the mechanism for doing that, by the way, is with a written contract, you get the person where there's an onerous clause to sign next to it. This demonstrates that they've actually read that particular clause itself and co-sign it. So both sides sign that particular clause. That's just a practical step that you can take to bring the attention to the other side. It's also good in terms of evidence. If the thing does go to court, oh look, here's the document. Yes, this clause, it might, Your Honour, it might be considered a little onerous, which is why we brought it to their attention. Here's where they've initialed that particular clause itself that we circled. Okay, and again, from you guys who may be enrolled, where you are hiring people, or you're engaging contractors, or you're getting into significant financial things. You guys may well end up being financial controllers. You are going to be the one literally signing these things off, writing the check. And so it's important. I think that's a useful thing to note. If things are in there, that usually you go find your legal team and say, this penalty clause for $17 million. You guys have worked this out, right? But you need to know about these things. You need to know about this particular rule. Just leave it on the back of your mind. Okay. Don't have too many slides. What I might do, I think, do you mind if we'll just carry on for another 20 minutes or so and just finish early? Is that better than having a break in the next few minutes? Okay, we'll do that. All right, next thing to know, implied terms. This is where we didn't actually say something. It's not something we negotiated about. It's not something we talked about. It's not something that is in the document. But nonetheless, the courts, they don't do this lightly, but the courts can say that there is additional terms implied into a contract. And there's three different ways this can be done, either by law, by fact, or by custom, and I'll go through each of those. All right. So a few things to note. In contract law, many of the legislative frameworks that sit on top of this, I guess, pure stock standard contract, rules of contract that we're learning, which has all these cases and rules of ye olde England, Parliament's jumped in lots of occasions and said there are certain terms that, even though we didn't talk about them in terms of, at the time of formation, the law will actually say, in this contract, all of these terms are actually implied. So here's some examples. Sale of Goods Act, if you purchase something, goods by description, you read a description, and the goods that you purchase don't match that description, even though we didn't talk about this as a term itself, the goods must be of what they call merchantable quality. There's definitions for that. We do this in week 6. There's a statute, the Sale of Goods Act, that says unless you've contract specifically removed this clause, you can actually contract out of this. You can actually have in the agreement, Sale of Goods Act 17 subsection C doesn't apply. You can do that, but if you haven't, this is going to form part of your contract. Employment contracts have an implied term, the duty of good faith. You actually have to maintain confidentiality and good faith with your employer. You can't just take all of the things that you've learned from them and sell them to the competition. All right, even though we didn't talk about that when we hired you, you are still deemed at law to have that included in your contract. Other ones, I'm not sure why I put this one in here. Patients can access medical records. I think because it went to the High Court. This was a High Court case in the mid-90s where they talked about that. You, as a medical patient, even though you don't talk about it, there is actually an implied term that says you can get your records off doctors. And the important ones that we'll be doing it again, I think week 7, we'll be talking about the Australian consumer law. There's a whole host of things. When you go to Woolies and you buy something, there is an implied term when you buy food that it will not kill you. It seems so obvious, and again, we can also do it when we get to the next part, applying by fact. It seems so obvious, goes without saying, but it doesn't matter. Parliament said food must be safe. You can't sell tainted meat. Parliament said so. And there's other things too. Goods must be, consumer contracts must be acceptable in appearance and finish, free from defects, safe and durable. All of those things are implied in contracts when you're purchasing them from a merchant who commonly supplies those goods. All right, and look, there are lots of these things. There are implied terms when you're buying and selling motor vehicles. The vehicle has to be safe. There's implied terms where you're buying and selling real estate, that you've complied with the Real Estate Institute standard forms and such like. There's, the law implies a whole bunch of terms and a whole bunch of both consumer and non-consumer, business and non-business contracts. Anything involving banking, insurance, and the employment, consumer stuff, they all have extra things that Parliament's jumped in and said it needs to be this and it needs to do that. And some of these you guys do, I think. I'm not sure if, you guys might not do employment law. I don't think you do. You can do. If you want to do employment law, Louise Floyd teaches that. She's very good. But you just notice that even though we don't discuss it when we hire somebody, you know, here, do you want to come paint my house? I'll pay you $50 an hour. There you go, come and do it. Not discussing these things, but as part of that employee-employer relationship is both sides are obliged to do certain things, and that's just implied by law, both common law, equity, and statute, largely statute. Right, that's kind of the easy one in terms of implying terms. You can, and again this comes from Cadalpha, apply terms by fact. Now this is tricky. The courts don't do this readily. They don't do it quickly. They don't do it happily. And they will do it if it satisfies all 5 of these things. These are elements of an implied term by fact. So first of all, you can't imply onerous or silly or dangerous or unusual terms into a contract. It must be reasonable, it must be equitable, it must be fair. You can't imply by fact terms which strongly favour one side or the other. That's the first point. Secondly, it needs to actually make the contract meaningful. In other words, if this term wasn't implied in the contract, it wouldn't really work. The term they use here is business efficacy. If the term wasn't implied in the contract, this whole basis of this contract would not work. Therefore, that is one of the requirements that we've got to have. It can't just be something small that we've just left out. That's not sufficient. It actually has to be substantial in terms of making the contract actually operate in the ordinary sort of business sense of the term. Third one, it has to be so obvious that it goes without saying. Both parties should be able to go, oh, well, of course this should be in there. So obvious that that particular term needed to be in this particular contract, that it goes without saying. It has to be capable of clear expression. In other words, you actually have to be able to describe it and define it in tangible terms. And this last but certainly not least, really importantly, you can't apply a term in a contract if there's already an express term in the contract which expressly goes against it. All right, so some examples. If I'm purchasing this boat from Jean, and I say, can you deliver it to me at my berth in the wharf? All right, it goes without saying, reasonable and equitable, necessary to business, the boat actually floats. It's so obvious that it goes without saying. It's capable of clear expression. The boat must float to get to the wharf. But if we had put a term in this written agreement for that last point, that 5th point, that Jean doesn't guarantee the boat will float, well, we talked about it. She didn't make that guarantee. Therefore, actually me saying, oh no, you're guaranteeing that it was going to float. No, not going to fly. So that's an example of something where you could imply it by fact, but again, if you put it and expressed it and mapped it out in the contract and there's an express term that goes against it, all bets are off in relation to that. Okay, courts don't do this readily, by the way. It's hard. It's a hard thing to do. Again, things only end up going to court when stuff's gone wrong. But this might come up. You may actually have contractual disputes where you've gone through the contract and realized there's something so important or so obvious we didn't even think about putting it in there. They said the boat has to float, for example. So obvious, but we didn't think of putting it in. That's where this can come up, but it's hard. All right. And you can also have this third one. This is pretty rare as well. Implying terms by custom only happens if there's some sort of industry norm, so that people in the industry would all think that all contracts in relation to that particular industry have this term implied in it. trying to think of an example. Okay, I was in software for a long time, and so buying and selling software, for example, if I'm selling, maybe for example, selling source code directly for whatever reason to a third party, selling all my source code, sure, then maybe, again, I'm arguing, this is just an example I'm thinking right now, that source code must compile. Maybe. We may not have put it into the contract itself, but source code that doesn't compile, this is completely and utterly useless. If you have to go through, maybe you've got to fix a little bit here or there, or maybe not. But the whole point of having source code is that you're taking it and using it and compiling it into applications. And those applications work. If it doesn't compile, you can't build applications. It doesn't work. Maybe. This is an example. I can't. All right. Again, it's pretty rare, these things. Constant, I think this was to do with insurance. They failed in that situation. I think it was something to do with insurance brokers in terms of the norms that they have in relation to that. But it's really hard to prove. Those last two, very, very difficult things to prove in terms of industry norms. Because it's quite easy, by the way, to wheel someone else from the industry in and say, nah, that's not the norm. You can buy source code that doesn't compile all the time. Tough luck. All right, let's go to the next slide. All right, now before I'd mentioned these things called collateral contracts, the big contract and the little contract. This is where you've got a big contract. And the reason why this area of law exists is because the courts of ye olde England don't want to be the destroyer of bargains. They will bend over backwards to make sure when two parties come together, form the agreement, it's almost sacrosanct. And they said in the British legal system that the bargain is to be upheld. And one of the ways they do that in situations where representations have been made that don't form part of the main contract because they're excluded, either through the parole evidence rule or because the court thinks that the contractual intention test isn't met, so it remains a representation and not a term. They can, however, say, look, here is a big contract. We don't want to be the destroyer of bargains. We're going to leave that intact. All right, so I'm entering this contract with Gene to develop a block of units for $1 million. That's fine. All right, but we're going to have this other statement that was made nearby involving me trying to get, or her trying to get, her niece into Townsville Grammar. All right, that's something that I've said I could do. And in terms of consideration, what she offers, I offer to do that particular bit of performance, and she offers to enter into the main contract. And the key thing to note is that the main contract stays intact. We can argue about this collateral contract. I didn't get the niece into grammar, therefore you can seek some sort of compensation under this collateral contract, but the main contract stays intact. Our rights and obligations are enshrined in that contract, and they do not change. That's how collateral contracts work. The whole idea is that they are this separate, independent contract in which the consideration for one party is to enter into the big one. Does that kind of make sense? It's a little bit tricky to get your head around this, but it's important to note because people say all sorts of silly things. Real estate agents are real bad for it. So all sorts of silly things in order to get people to sign. Sign here, sign here, sign here. That's why in this day and age, your little mobile phone, they all have recording functions. When you're entering into negotiations, oh yeah. Don't think the other side aren't doing this to you too. And just make note that usually that evidence, by the way, can't be used, but it's very, very helpful when you go back and make contemporaneous notes about that conversation. All right. Right, so make note that the collateral contracts are contracts. They are fully fledged, fully functional, separate contracts with independent force. The fact that they're made, often oral, that's fine. As long as you can prove that both sides made these particular representations, or one side made representations, the other side entered into the main contract. But make note these collateral contracts can't be inconsistent with the main contract itself. So, for example, I can't say as part of this, oh, let's enter into this contract for $1 million for this development, and if you do, I'll go and organize to do double glazing in the windows. I'll just go and do that for all of the windows. Yeah. The thing is with that, when you go and look at the main contract, which says the windows are to be this and that's to be this much and they're to be paid that much, if I'm making this comment about double glazing, that's inconsistent with the terms of the big contract. And therefore, it can't be a collateral contract. It can still have some other form of legal force. Again, it might be a misrepresentation, but it can't be a collateral contract if the terms or performance of the terms is inconsistent with the main contract itself. Okay, it takes a little bit of thinking about. If you're making representations that don't form part of the main contract, either because the contractual intention test fails or parole evidence rule says we've enshrined this in writing, all these oral stuff is just excluded. Oh, but if you sign on the dotted line, I'll go and get you a new toaster. And it says, and the main contract says, oh, I don't know, the house is to have no toasters or something stupid like that. I don't really know, but it can't be inconsistent. All right, that's the last thing to do with the contractual terms per se. I'm just going to spend a little bit of time talking about interpretation. All right. I probably should spend more time on this. I think I've been meaning in previous years to actually flesh this out a little bit because reading contracts is really important, and I only spent one slide on it. So just from a high-level perspective against Cadalpha again, the starting point in a read a contract is you just read it. That sounds really dumb when I say that out loud, but you are literally picking up the ordinary and natural meaning of words. And that's not, strictly speaking, the dictionary definition. Dictionary makers didn't write your contract, you did. You read a particular word, it'll have an ordinary meaning. You can go to the dictionary to confirm what that meaning is, but that's the same with reading statutes. You start with how it reads ordinarily. Okay, and let's face it, these things are only a problem when two people disagree about the ordinary meaning, and then someone else has to read it, the court. Judge has to go through and read it. And the key thing to note is that it is not about what I think, it's not about what you think, it's about what an objective observer would think the intention of the parties was. Objective, a reasonable person looking in, reading this instrument to try and determine our objective intention at the time of formation. Okay? That is fundamentally how contracts are interpreted. That is just the main thing you have to take from this. What we think, irrelevant. What would a reasonable third-party observer think when trying to determine what the objectives of the parties was when they're reading it? Okay? The actual intentions or our subjective beliefs are totally and utterly irrelevant when interpreting contracts. It's not what I think, it's not what you think, it's what a reasonable third person reading this objectively would think. Okay, does that make sense? Because it is actually an important point, even though I sort of downplay it because it's not, it's just one rule of many rules you have to learn in terms of contract, but it is one of the more important ones. In fact, there's a whole bunch. This lecturer has a bunch of really important rules. The parole evidence rule, really important. The Lestrange's case, the effective signature, really important. And this one. Like, just in terms of practice, your professional practice, and from this point, doing things with contracts, those are three really helpful rules to remember. Probably, to be honest, forever and a day. If you can take that away from today, that's good. That's good. In 10 years' time, you forget all the rest of this stuff. Contra preferentum and all that rubbish. But just remember those things. You sign it, you're deemed to have read it. When you're, if you put it in writing, it's going to exclude all the oral statements by default. It's parole evidence rule. And the third one, when reading a contract, it's not what I think, it's not what you think, It's about what an objective third person reading the contract is going to think. And sometimes, by the way, when we're really angry and emotional about and reading contracts, you've got to step away. You've got to actually get someone else to come in and read it, because you get too tied up with it. Particular meanings of words can sometimes have a strong emotional, particularly when you're angry, because you reckon the other side's in breach. This can happen. Sometimes it's better to let a third party come in and read it. Okay. Evidence of negotiations. That's another thing as well. And again, this goes back related to the parole evidence rule. If you negotiated stuff, even if you wrote it all down, and then you enshrined it in writing, this earlier stuff is excluded when the courts are trying to determine what the intention of the party was. You can't adduce that as evidence. It's a rule of evidence. You can't adduce that stuff. Unless, if the parties consent to it, or it's an express term in the contract that says you can, and so on. But by default, you can't. All right. And there's one last rule, one last slide, which is kind of cool. I always quite like this rule. It doesn't really come up much, but it's to do with written contracts. It's an old rule, even though Northern Marine is relatively recent. It goes like this. If two parties have a contract, all right, they come together and negotiate it, one side goes away and writes it, as a rule of last resort, if the court is looking at a clause and can't determine objectively what the intention of the parties were, it's still ambiguous, as what we call the last chance salon, they will actually rule against the party who drafted it. I'll say that again. If the court, after applying the ordinary rules of contract interpretation, in other words, what would a reasonable person think that the intention of both of the parties was when they came together to form this thing, all right, when trying to interpret ambiguities in the contract, if after doing that they still can't work it out, as the last chance, common law, the courts will actually hold against, but if there's any ambiguity still residing, against the party who wrote it. It's their fault. Their fault. They wrote it. They wrote it. It's ambiguous. Courts can't work out what the intention was. It's still ambiguous. We're going to rule against the party who drafted it. I'll leave that one on the back of your mind. And that can be real complex, particularly in situations where, I bought a house around the corner about 4 or 5 years ago, and the real estate agent, I think I mentioned this earlier, he was really dumb. Just dopey. And he would literally gave me the contract and had all these errors in it. So I'd fix some of them. I think I might have told him actually what the errors were. Sent it back to him, and he came back, fixed it, still had most of those errors in it, and then introduced some new ones. And so this went backwards and forth between me and him. And I'm trying to work out who was the person who drafted this. Was it me? Was it him? And admittedly, it's my real estate agent. It's kind of a moot point. But if you've got a document and there is a contract and it's going backwards and forwards, sometimes it can be hard to work out who actually drafted it, inverted commas. Sometimes it's easy. It's presented by one side. Sometimes it can be a little bit harder than that. And just make note, this is the last chance salon. It rarely comes up, because usually ambiguity is resolved one way or the other by the court before it reaches that interpretation rule, contractual interpretation rule. Okay. Oh wow, we finished quite a bit early. Yeah, I don't have anything else to add for this particular class in this particular session. But just make note, those 3 things. If you tuck them away forever a day, I'm going to feel like I've done something right. Well, what would be really bad if I walk over to the auditing class and I ask literally my last year's class, who are doing that one now, what they remember, and they'll be like, no, Simon, none of that. I don't remember nothing. You waved your arms a lot. Okay, guys, so I said I'm happy to end these there, and I'm also happy to take questions if you guys do want to have questions about your assessment task, the new one. Like I said, in terms of dates, we're going to, I'm hoping to actually get your reflective piece back to you tomorrow. I'm going to try for tomorrow. It'll be definitely before the end of the weekend. And